the Honorable, the Justices of the Appeals Court, now sitting at Boston within and for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
Good morning and welcome to the Appeals Court. First of all, thank you for your patience. We were hearing a Zoom hearing for our first case. I'm Judge Milkey. To my right is Judge Neyman. To my left is Judge Smyth, and we are your panel on the 5 additional cases we're hearing this morning. Looks like at least most of you are familiar with our rules, 15 minutes per side, no opportunity for rebuttal. I want to assure all parties that we have read the briefs. We are familiar with both the facts and the main arguments. And I mention that because to the extent possible, we urge you to cut to the chase in terms of your arguments, because 15 minutes is generally not a great deal of time. That said, if you feel like you've made your arguments, there's no shame in sitting down. As one of our former colleagues used to say, if you hit a home run, you don't have to run the bases twice. And with that, I will call our first case that we're hearing live today, Commonwealth versus ELIBERT, 2021 P257.
May it please the Court, my name is Attorney James Methy. I represent Joseph ELIBERT in this appeal. The first issue in my brief is that the judge committed reversible error by instructing the jury on a lesser-included offense of indecent assault and battery. Concerning the rape indictments, the alleged victim here, who I'll call KT as I did in my brief, testified that my client put his fingers and his tongue in her vagina. There was no basis for giving a lesser-included instruction of indecent assault and battery because there were 2 separate indictments for indecent assault and battery, were counts 3 and 4. Penetration was never disputed by the defense in this case, which case law says is usually the reason a judge would give the lesser-included instruction offense. Instruction, I should say.
Counsel, you say penetration was not in dispute. There was certainly a dispute over whether or not, for example, the defendant had stuck his, I believe his allegation was, whole hand inside the victim. And another issue you raised goes, there was an expert that testified about signs of physical trauma and stuff. How can you say that penetration was not in dispute? Couldn't the jury have just concluded, well, we're skeptical about penetration because of no physical signs of trauma, but he touched her inappropriately?
Well, I said that because defense counsel in his closing argument never disputed penetration. Basically, his defense was that it didn't happen, that she had made up the allegations for reasons that he explained.
But the Commonwealth still bore the burden of proving penetration, and ultimately the jury apparently concluded they did not meet that burden.
Well, I think there's a question about what the jury concluded, because they found him not guilty of the 5 original indictments. But if I could just get into, I think the judge's reasoning for giving the lesser-included offense is incorrect. He said, couldn't there have been a licking without a penetration? But if you look at the case law, as I'm sure you panel knows, any touching of the area is basically a rape.
But the standard is if any view of the evidence would allow a lesser included, it should be given, correct?
Yes.
So what of the fact that the defense elicited on cross-examination of the victim that in 2016 she told the district attorney that this was just a touching? And if you look at volume 3, page 82 of the transcript, it's that during that interview you mentioned just touching, and her answer was yes. And then in 2018, the touching had, quote unquote, become a rape. And defense counsel emphasized this in closing. That's volume 5, page 46, where he said, so in 2016, she says it was a touching. In 2018, she comes back and claims it was a rape. From that testimony and from those arguments, why would a lesser included instruction not be appropriate?
because he was charged with indecent assault and battery, 2 counts, counts 3 and 4, based on what you said about the touching.
Is that clear, or were those separate acts? In other words, it seems to me that the one possible, again, any view of the evidence, one view of the evidence would be that those touchings, quote unquote, morphed into rape, according to the victim, and there was additional evidence which supported 2 additional charges of indecent assault and battery.
But the rapes and the indecent assault and batteries were a different time frame, basically. The indecent assault and batteries were, according to the indictment, January 2016, whereas the rapes were supposedly 2011 to 2016. So I think they're kind of separate here, at least according to the way it was indicted.
But what if the testimony is ambiguous and it's not clear as to which touchings were being referred to when she disclosed to the district attorney in 2016 and 2018? I mean, again, one view of the evidence would be that her disclosure in 2016 of the touchings and her subsequent disclosure in 2018 of the rapes involved the same conduct. And the indecent assault and batteries that were charged involved other conduct.
I'm not really following. I mean, I think I explained as best I could. I think they're separate indictments, separate incidents. The judge never told the jury what acts would constitute the lesser-included offense. I think that's a real problem. There was a specific unanimity instruction on the rapes, because there was 2 different, on the digital rape, there were 2 different instances, well, more in the house and then in the car, but he never gave specific unanimity on the indecent assault and battery. In fact, never told the jury what would constitute the acts they could find to find him guilty of lesser-included offense, and I think it's a problem because of the prior bad acts that were let in. I'll get to that in a minute, but I just wanted to bring out one other thing. The Commonwealth said in their brief that KT testified that during the digital rape, there was some evidence that there was a touching of her butt. And if you read the transcript carefully, she does say that. But the problem is, number one, the judge never said anything about that when he was giving his reasoning for giving a lesser-included offense. And number two, it was never brought out by any of the parties during the numerous conversations they had about giving the lesser-included offense. Nobody said anything about, well, there was some allegation of some other touching while he's supposedly committing the rape. And the other problem is that when the judge instructed the jury on the prior bad acts in his final instructions, he basically told them, my client, Mr. ELIBERT, is not charged with any touching prior to January 2016. So now they've been told they can't find indecent assault and battery anything prior to January 2016, which is when these supposed touchings during the rape happened, would be 2011 or 2016. So the judge is telling him, basically, you can't convict him on that. So what are they convicting him on? I think it's totally unclear as to what the jury found.
Unless my colleague has follow-up questions on that.
I do, but go ahead. I defer.
Go ahead.
No, go ahead.
I want to return to the issue you were just saying before Judge Neyman asked his trenchant factual question. You appeared to be saying that under the case law, you don't have, when you have an alleged oral rape, the Commonwealth does not have to prove penetration. And I want to test that proposition with you. Is it really that the Commonwealth doesn't have to prove penetration, or that penetration is presumed under those circumstances? And if it's the latter, why couldn't the jury conclude that even though there is oral contact, that they weren't satisfied that it was in fact penetration?
Because of the testimony of KT that his tongue and fingers went in her vagina.
But they didn't have to credit that testimony. They could have credited that it went on the vagina but not in the vagina.
I don't know, again, what the jury's crediting. I don't really see how they could find him guilty of a lesser-included offense based on the testimony.
Well, let's talk about the digital rape briefly. The victim testified that defendant put his hands inside of her pants, and she said, "through my underwear." Is there an ambiguity in that statement? I know she subsequently said that he then put his finger in her vagina, but when she said, "put it through my underwear," isn't there an ambiguity in that where a jury could find that through the underwear meant pushing through, as in on top of and pushing through the underpants with them on, but not necessarily inside her vagina or touching the, as the case law says, labia or vulva? And again, the root of my question stems from the case law that says if any view of the evidence supports a lesser included, one should be given. Could you address that, please?
Well, I know the Commonwealth argued that in their brief, that there was that touching again. But again, I'd go back to my statement about when the judge instructed on the prior bad acts, he said you can't consider any touching prior to January 2016, which is, again, what that was, because it was part of the rape scenario. So that was prior to January 2016. So I have the issue with he's telling him you can't convict him of that and indecent assault and battery and anything that happened before that. So.
But wasn't that one of the two events that was the basis of the aggravated rape charge?
Yes.
So that was clearly one of the aggravated rape charges that was before the jury, and the issue is whether or not a lesser included instruction was warranted. And the victim testified, he touched me through my underwear.
Well.
So again, I asked the same question. Assuming then that the aggravated rape charge, for purposes of my question, I want you to assume that the aggravated rape charge was properly before the jury, that 2011 digital rape. Is the through my underwear testimony sufficient to warrant a lesser included offense, charge, or instruction rather?
I would argue no, Judge. As I said,
Sorry.
Based on the prior, I think the jury has to be totally confused at this point because the judge is telling them they can't find him guilty of indecent assault and battery based on anything that happened before January 2016, and apparently it seems to me that they did.
Okay, I'm going to ask you the question this way. Assume the prior bad acts issue. I know your argument is you can't divorce the two, but for purposes of my question, assume that the prior bad acts issue is off the table. Okay? Does the testimony I just referred to about putting his hands through her underwear, would a lesser included be warranted, a lesser included instruction of indecent assault and battery under that situation? Putting aside the prior bad acts. I know you say we can't, but I'm asking you the question.
I would have to argue no. I don't think it'd be warranted on that. When the victim is clear as to what exactly happened, that he placed his fingers and hand inside her vagina.
Okay.
The judge should have allowed trial counsel's motion for a judgment notwithstanding the verdict based on that he made after trial, based on the arguments I just made. It ties in with the fourth issue on the prior bad acts again, that the judge abuses discretion by admitting the prior bad acts. Prior bad acts were that KT testified that I think 3 times or 2 or 3 times a week for a period of 3 years he was touching her. The judge admitted it for a course of conduct, which I can understand, and ordinarily I'd say probably I wouldn't have a good argument that it shouldn't be admitted, but I think in this particular case it just made it completely confusing to the jury about what they were supposed to be considering on the indecent lesser included offense, because that was the only evidence. The prior bad acts are the only evidence that there was a touching prior to January 2016. The judge did not instruct the jury on the prior bad acts at the time KT testified, which the case law says is critical to reducing the prejudice. He also used the wrong word in his final instructions on the prior bad acts when he said, quote, there was evidence showing defendant touched her, end quote, instead of the language of there's evidence of acts allegedly done by the defendant.
Any objection to the instruction at trial
Yes,
on that basis?
yes. I'll move on to the second issue in my brief. I don't have too much time left. Concerning the first complaint evidence, the judge abused his discretion by admitting the...
Wait, I apologize. Where is that, the objection to the judge's, on that basis to the judge's instruction? The only objection I see is volume 5, page 94.
From my recollection, at least in my notes, he did object at the time the testimony was admitted, and he objected to the instruction. That's what my notes reflect. Since I only have less than a minute left, I guess I'll rest on my brief on the other issues, and there's no further questions.
With the panel chief's permission, we can give you a few more minutes if you'd like, because we've drilled down on one issue. If you'd like to take
I can
another couple minutes.
Briefly address my second issue, which is on the first complaint evidence. Number one, the actual first complaint witness testified, quote, when Katie told her what she said happened, quote, "It sounded pretty real to me," end quote, which is improper, as the first complaint witness is not allowed to testify about her opinion about whether it was true or not. Katie testified that on January 26, 2016, she spoke to various people, the school counselor, went to the hospital, and then to the police station. And the detective testified that he got involved in the case when she filed a report about a sexual assault. There's case law about that the police shouldn't be testifying about an investigation, that embellishes the complaint. There was also testimony from KT and her mother about her family's reactions to her complaint, that she testified she told her father, her mother, and her grandmother, and what their reactions were, that their mother was upset, shocked, was crying, never saw her cry like that before. And the ADA at trial commented on in opening and closing on all her complaints from January 26, 2016, which were not the first complaint, and also the family's reactions to her complaint, which is also improper. No further questions. I ask you to reverse the judgments. Thank you.
Counsel, thank you very much. We will hear from the Commonwealth.
Good morning, Your Honors. May it please the Court, Elizabeth Martino on behalf of the Commonwealth. And the Commonwealth is asking that this Court affirm the defendant's convictions. I'd like to start by addressing the first issue, which is that the judge properly instructed the jury on the lesser included offense of assault and battery in this case. As Justice Neyman has pointed out several times, the rule is that if on any hypothesis of the evidence, the jury could have found the defendant guilty of the lesser included offense and not guilty of the greater offense, then the instruction should be given. Here, there were 3 incidents that could have served as the basis of the rape indictments, and thus the lower, lesser included offense of assault and battery, indecent assault and battery. It was the digital and oral rape incident that happened in the apartment on the big couch, which was the first time that the defendant sexually assaulted the victim, and then later, when the victim was in 6th grade, the incident in the car, where the defendant would turn around.
With respect to the oral rape in the house,
Yes.
what is the basis for the lesser included? What facts serve as the basis?
Well, the testimony was that the defendant, licked inside of the vagina, inserted his fingers inside, also that his hand was on the the victim's buttocks at the same time. But I think the Russell case out of the SJC is instructive. It's cited in both of our briefs, 470 Mass 464. And in that case, the SJC said that the jury can consider, especially with a young victim, that a jury can have reasonable doubt as to the extent of contact. So they could...
But I know what Russell says. My question is, what is the factual basis?
Right. So I think as in Russell, here, the evidence is that, he licked her vagina, right? And so I think jury reasonably could infer that there was possibly non-penetrative conduct, right? That, maybe it wasn't inside the vagina, it was a young victim, and perhaps the extent of the contact.
Just to clarify,
Yeah.
are you saying that with respect to an alleged oral rape, the Commonwealth has to prove penetration, it's just that penetration can be presumed ordinarily through the use of the tongue?
I believe that is the law, yes, that it can be presumed. I think here on the testimony given by the victim, especially in light of the language of Russell, a reasonable jury could infer non-penetrative conduct from the testimony. Also, so the jury had many options, right? They could infer non-penetrative conduct from that testimony. Also, they could
Can a jury infer non-penetrative conduct when the testimony is unambiguous that there was penetration?
I think that's what.
Say if the testimony is unambiguous that there was penetration?
Well, I think that's a different scenario than what we have here, so I can't answer that exactly. Possibly.
I'd still like you to answer the question.
Yeah, I think possibly if it's totally unambiguous, which I think is that Zanetti case that's cited in Russell. But here it's not totally unambiguous, and it's very similar to Russell. And it is, this young victim who's testified to lots of sort of conduct by the defendant. A lot of it was non-penetrative, and I think that the jury here could have, disbelieved perhaps the testimony about the penetrative conduct and inferred non-penetrative conduct. A reasonable jury could have done that. That's as to the oral rape, right? So it would be the lesser included indecent assault and battery, and the digital, right? There was testimony that he was touching her and grabbing her all at the same time, and that he had his hand on her buttocks at the same time.
Okay, let's talk about that. In the brief, and I acknowledge you didn't write the brief. In the brief, the Commonwealth argues in part with respect to the oral rape that the hand on the buttocks could serve as the lesser included. Do you still want to make that argument here today?
I think that it is, it's all part and parcel of one incident, and it's clear to the jury from the victim's testimony that the defendant grabbed her, put her on the couch, was holding on to her, and, was licking her and touching her.
Could the Commonwealth have indicted the defendant separate and apart from the oral rape for indecent assault and battery for the hand being on the buttocks in that same incident? Seems to me
Yes, I think, yes.
And if that's the case, then it's not a lesser included, right? A lesser included, at least under the elements-based approach,
Yeah.
means you take away an element, in this case, the touching of the vagina with the tongue, or the penetration with the tongue. You take away the element of penetration, and you have a lesser included. The hand on the buttocks, as you just acknowledged, is a separate actus reus. Could have been indicted separately. I don't see how that could serve as a lesser included offense under any of our cases.
I see your point. I see your point, Your Honor, and I guess my only argument would be that because it is all sort of a part and parcel of one conduct, he's grabbing her and licking and touching all at the same time, that it isn't necessarily like a separate, reus, as you say, Your Honor. So I would argue that it could be a lesser included because it is part and parcel of one conduct. But it's not my only argument. It's not necessary to find that because there is this inference that the jury can make of non-penetrative conduct from the victim's testimony here. That's the first and second sort of incidents, right, that can serve as the basis of one of the indictments, right, the big couch episode, which was the first time that the defendant sexually assaulted her. And then separately, there's the motor vehicle, where the defendant turned around and would put his hands in the victim's pants. I think this one's much stronger for the Commonwealth, that the lesser included should have been given because there, I think the non-penetrative conduct is very clear. It's not just an inference, but he said, the victim said he put his hands in her pants. And I think the victim also said he put his hand fully, like his whole hand in her vagina, but I think that, under Russell, the jury was free to disbelieve that, especially in light of the expert testimony, and believe only that the defendant put his hand in her pants, which would be indecent assault and battery, not necessarily digital rape. So there's the three different instances, and I think each of those, and where a specific unanimity instruction was given, each of those could serve as the basis of the indictments, and each of those could be, a jury could reasonably find indecent assault and battery based on non-penetrative conduct as well. And if the court doesn't have any other questions on that, I would just note the prior bad acts, I think, it was very clear that this was a sort of separate conduct. The victim testified just after she testified about the first time that the defendant sexually assaulted her, the big couch incident with a digital and oral rape. She testified that the defendant would also, excuse me, let me just find it. That he would also, on the small couch, there was a series of small couch conduct. The defendant would ask the victim to sit on his lap, would straddle the defendant facing him. The defendant would lick her breasts, sometimes over her clothing, sometimes licking the bare breast, and feel her buttocks over her clothing. And so I think that conduct was all sort of separately testified to, and that's what the trial judge was referencing in his final jury instructions when he said you can't consider the evidence of the touching of the buttocks and the breasts prior to 2016 as because it's uncharged conduct. And the indecent assault and batteries that were separately charged in 2016, I don't think can be confused with these three, episodes that serve as the basis of the rape indictments. It was clear also from the victim's testimony that these happened earlier than 2016, which is when the abuse finally ended. Okay, and if there's no other questions on that, I don't know if the court has any questions on the first complaint issue. I think my colleague.
I just have one final question.
Yes.
A specific unanimity instruction was given vis-a-vis the aggravated rape charges, correct?
Yes, Your Honor.
Was it also given as to the lesser included offenses or no? Or as to the indecent assault and battery?
So the judge instructed specifically on the 2 counts of aggravated rape, then gave a specific unanimity instruction. Said to find the defendant guilty, you must all agree that it is be unanimous as to the place and the conduct that occurred, and then went into the lesser included and said, if the Commonwealth has failed to prove aggravated rape in the manner set forth, you should consider whether they proved assault and battery, indecent assault and battery.
So was the specific unanimity instruction just provided as to the aggravated rapes or as to anything else?
No, just as to the aggravated rapes, but I think if you read the instruction in its entirety, it becomes clear that it's relating to the aggravated rapes, but but then the judge says, if you do not find aggravated rape beyond a reasonable doubt, you may consider indecent assault and battery. So it refers back to the specific unanimity charge. I think as a whole, when you read it, it's clear that it does refer back to the specific unanimity.
But there was no specific unanimity instruction as to the separately charged indecent assault and battery counts, correct?
No, he says, so he gives the aggravated rape charge, he gives a specific unanimity in charge, he then gives the lesser included, and which he explains is indecent assault and battery, and then he says there's also 2 separately charged indictments as to assault and battery, and now I will instruct on the elements of that. Does that make sense?
Yes, but it doesn't answer my question, which is, did the specific unanimity instruction, was it clear as to whether or not it applied to the separately charged indecent assault and battery counts?
I think as a whole, it does, because it's all given in quick order, one after the other. So it is the specific elements of aggravated rape, specific unanimity, right? And because there's sort of 3 incidents that underlie those indictments, The judge says specifically, if, for instance, half of the jurors conclude that a digital rape occurred in the apartment and half the jurors were convinced that it occurred in a motor vehicle, you would not have a unanimous verdict under those circumstances. So he gives sort of hypotheticals to show what would be and would not be unanimous based on the facts in this case. And then he goes, he finishes defining aggravated rape. He then goes into the lesser included. I think it refers back at that point, that if the jury does not find aggravated rape beyond a reasonable doubt, it can consider whether there's indecent assault and battery on those indictments as a lesser included, which would refer back to the specific unanimity. It must be either digital rape or oral rape. It must be either in the car or in the apartment, and you must all be unanimous.
But doesn't the hand on the butt complicate that? Because that could support indecent A and B, but not the aggravated rape?
But I think that, again, it could only support the indecent assault and battery as a lesser included offense, because the other separately charged indecent assault and batteries were later in time. So that conduct, the first assault, which was the digital and oral, the basis of the digital and oral rape indictments, were earlier. So they were when the victim was 9.
I understand, but couldn't half the jury convict him based on the hand on the butt and half the jury convict on the...
Oh, I see. I think actually that the instruction is clearer, although it does tie as an example to the, half concludes that it's in the car and half concludes that it's in the apartment. What he does say more generally is that you have to be unanimous as to the time, the conduct, and the place. So I think whether it's the hand on the butt, or the inference of non-penetrative conduct, the judge instructed had to be unanimous, as well as the time and the place. So he did tie it as an example to the car versus the apartment, but he didn't specifically say those were the only things that they had to be unanimous on, if that answers Your Honor's question. As to the other issues, I think I'll just rest on my brief unless the court has any questions.
Hearing none, thank you both very much. The case is submitted.
Thank you, Your Honors.
Our next case is Commonwealth versus Thompson, 2022 P678.
Good morning, Your Honors. Andrew Karasi on behalf of Mr. Thompson.
Could you just point the mic toward you?
Certainly, yes.
Yeah, thank you.
Your Honors, Mr. Thompson is entitled to a new trial since trial counsel rendered ineffective assistance of counsel in failing to summons the only witness who was competent to testify to the exculpatory fact that the alleged victim's cell phone was not discovered in Mr. Thompson's car when he was stopped after allegedly stealing it.
Isn't that factual point established to the extent it's established by something outside the trial record?
It's not, Your Honor. The fact that the phone was not discovered in his car was put on the record. So,
How?
So trial counsel intended to elicit this information through a Northborough police officer. And of course, she was rightfully excluded from doing so, but the court asked her, what's the proffer? And she said there was no phone. So she put on the record that if she was allowed to inquire of the Northborough police officer, that she would have elicited that there was no phone. So I think that there is factual support for the idea that there was no phone because she said that that was the proffer. So I don't think it relies on anything outside of the trial record. And I do just want to speak briefly to that point on the procedural history of this case. Now, I understand that ordinarily the preferred method for an ineffective assistance of counsel claim is through a motion for new trial. However, the purpose of a motion for new trial is simply to expand the record when the record, as it exists, is not sufficient to resolve the claim. However, where the entire basis of the ineffective assistance of counsel claim is on the trial record, it may properly be raised as a direct appeal. And here, and I get into it shortly, but here there was no reason to expand the record because, as I said,
speaking only for myself, when I look at the trial transcript, I'm confused in terms of what was found, because it looks like a phone was found, but there's some question whether it was his or hers.
Well, I don't know that there really is any question on the record as it stands. So the way that it played out, of course, is, as I said, that the trial counsel put on the record that there was no phone, and then there was no dispute. So the Commonwealth, of course, produced in discovery the inventory report. The Commonwealth knew what was found in the car. If her phone was found in the car, I think it's a reasonable inference to suggest that there would have been pushback for a claim put on the record that there was no phone, and there was no pushback.
So when you say it was undisputed, you're saying the evidence at trial was undisputed that no phone was found?
I think that the record is undisputed. Obviously, it wasn't introduced into evidence at trial, but when we're referring to what's indisputed on the trial record for purposes of whether or not a motion for new trial needs to be had before, it's the record as a whole. It's not necessarily what was introduced at trial, it's what's on the record.
Let me ask it this way. Was there any evidence at trial as to whether or not a phone was found?
There was no evidence admitted at trial as to whether or not a phone was found. That's absolutely correct.
So there was no evidence at trial that the police or anyone retrieved the cell phone?
That is correct.
So if there was no evidence, and this is a bench trial, the judge is presumed to instruct himself correctly.
Of course.
So then the judge, by definition, would have had to have found that there was no evidence of a cell phone being retrieved, right?
So it wasn't, it's a little bit different, I think, to get confirmatory evidence from a witness who says that I stopped this person, I searched the car, I performed an inventory search, and there was no phone. I think that that's materially different from just the absence in the record. In other words,
It would have corroborated the absence of evidence, but it
would have
wouldn't have.
corroborated, I think, in a material way. Because really, when you have no evidence, I don't know what happened to the phone. Maybe the phone was on Mr. Thompson, and I understand it's not an element of the offense, so that perhaps is why no evidence was introduced of whether a phone was recovered on him. But when you have affirmative evidence that he was stopped and he didn't have the phone, I think that that's different than just an absence of anything on the point. And I do think it's materially different here for the reasons I stated in my brief with respect to the alleged victim's credibility. Now, I'll get into it now, and I discuss it at length in my brief about the alleged victim's credibility. And here, ultimately, just skipping to the prejudice argument here, I suppose, that if this witness was summoned and there was affirmative evidence introduced at trial that he was stopped, there was no phone found, I think that that would have made a substantial difference in the analysis of the alleged victim's credibility because
But I'm looking at the offer of proof. This is page 81 of the
Yes.
trial transcript. And counsel says, in the car, there's a personal property inventory that I would offer of proof next that shows a cell phone that doesn't implicate what they've done with it. Is it her phone? Is it his phone? There's an allegation that he's taken something that nobody seems to know where it is to prove that he had it. It doesn't sound like it's established that her phone was not found.
I understand the court's point with respect to the later statement made by trial counsel, but I would direct the court to what was stated before that, which is that she says, what's your offer of proof? The court inquires of counsel, and she says, this is also page 81, she says, I think the offer of proof, Your Honor, is there's no phone. There's no phone recovered. And so her later statement about this is really in the context of the notion that there was no phone found. So she does talk about, well, there was two phones. And she does say, well, I don't know whose they are, but I would suggest to the court that the court can find on this record that there was two phones in the car, but none of them was the alleged victim's phone for two reasons. One, because she says, right above the line Your Honor has pointed out, there's no phone recovered. And second, that if the alleged victim's phone was recovered on Mr. Thompson, I would suggest that the court can find from this record, a reasonable inference from this record, that the Commonwealth would have called the state police trooper. That would have been extraordinarily inculpatory evidence that I think the court can find by a reasonable inference that the Commonwealth would have called a trooper to elicit evidence that the alleged victim's phone was found on Mr. Thompson. I think that that's extraordinary evidence for the Commonwealth if it were true, but the fact that they did not call a state police trooper as a witness, I think that the court can find on this record.
But trial counsel got to argue that point.
I'm sorry, I got to argue.
Trial counsel got to argue the point in her closing that they didn't produce a phone. And as you note, it's a bench trial, so she's arguing the point. So to the extent there can be a reasonable inference along the lines you're saying, she was aided by that in making her argument that there's no evidence that the phone was found. So didn't she get at least
And I suppose...
two-thirds of what she was asking for?
She got some of what she was asking for, I suppose, in the sense, and this goes back to the earlier question, which is really the difference between no evidence at all on the point and then favorable exculpatory evidence. She could say, well, there's no phone recovered. And of course, as the Commonwealth points out in their brief, they don't have to prove what happened to the phone. But I'm suggesting to the court that it's materially different to say, to have an absence of any evidence on the point and to allow trial counsel to say, well, you didn't hear what happened to the phone, versus having this, I think, very exculpatory evidence when you have an officer saying, I searched the car, it wasn't there, therefore he didn't have it. And I think that's different because when you don't know what happened to the phone, it still resorts back to the alleged victim's testimony that he stole it. But when he doesn't have the phone on him, I'm suggesting to the court that that's substantial evidence that it wasn't stolen and that the alleged victim's testimony that it was stolen was not credible. And I think that if the court was able to hear evidence that the phone was not recovered on Mr. Thompson, it would have enabled the court to find that her claim that it was stolen was not credible.
Two questions, counsel,
Yes.
on this very exculpatory evidence.
Yes.
Why would a fact finder infer that someone who took a phone in that manner would keep it on his or her person or in his or her car?
Well, and that's a fair point, I suppose, that the Commonwealth could have argued in rebuttal, which is to say that, well, we don't know what happened to the phone just because it wasn't found on him. Certainly, as the court points out, is not proof positive evidence that he could, I mean, frankly, I think what the court's getting at is he could have disposed of the phone, right? But it's still important evidence to say that in circumstances where you would expect him to have it, that he didn't have it. So certainly the Commonwealth could have rebutted.
Why would you expect him to have it? How long after he left the parking lot was he stopped?
It was shortly after. It was the same day, it was shortly after. Admittedly, I don't think that it is on the trial record, the exact time that he was stopped and how quickly after, but I think that the record supports the notion that he was stopped reasonably shortly after the incident under circumstances where, had he taken the phone, it would reasonably be expected that he had it. Of course...
I'm not sure the record supports that. Let me ask you my second question as to the credibility, how that may impact the witness's credibility. We have a civilian witness who testified that he heard the victim yell, "Help, he's hitting me,"
Yes.
saw a person leave, saw the named victim with bruises, injuries to her face. How would the absence of a phone affect a fact finder's assessment of the victim's credibility based on this evidence?
Sure. So I think that the alleged victim's credibility was questionable for a number of reasons. I think, in short, that her story and the way that she told it, for a lot of reasons, made no sense. Now, in terms of the witness that you speak of, he actually brings some interesting points that I think really raise the issue of her credibility, which is to say that she testifies effectively that Mr. Thompson came, she rolled down her window, and that he punched her in the face through the window. But this witness, who has no stake in the game, frankly, and if anything, he worked with her, he would maybe have an interest to her, but frankly, he's an objective witness. He testifies that after she gets out of the car, she gets out of the passenger door and walks around the car and rolls down the window. So you have an objective witness who's basically saying that her story that she rolled down the window and was punched in the face through an open window was frankly a lie. Why else would she have then gone around the car and rolled down the window if she'd already done that and gotten punched in the face through the window? So that's part one. But additionally, she tells this story. She says, well, after he punches me through the window that I guess was not really open, she says, well, I dove to the right side of the car. And then after that, he opens the door, the driver's side door, and pushes her from the driver's side into the middle of the car. So it doesn't make sense. She says she dove from the driver's side to the passenger side, but then after that, Mr. Thompson somehow pushed her from the left to the middle, so that doesn't make sense. She really couldn't even articulate how many times he struck her. She couldn't articulate, I think, to the point of the phone, she couldn't really articulate when it was stolen. She says, oh, he took it, I think she says, when he was leaving, and then at another point she says, oh, he took the phone before, during, and after the assault. So nobody really knows when the phone was taken. And so that, coupled with all these other issues, and in particular, if you introduce evidence now that the phone wasn't found on Mr. Thompson, you have this shaky testimony that's very questionable and impeached by an objective witness. And the testimony about the phone itself is very questionable. When was it taken? She doesn't seem to know. Before, during, and after. Maybe it was after. I don't know. But now, in circumstances when you would expect to find the phone on Mr. Thompson, it's not found on him. I think that would have been sufficient for a reasonable fact finder to find, you know what, I don't believe her when she says that she took the phone. And so I think that's important as it relates to prejudice on the larceny count. And so I think prejudice with the larceny count is maybe a better argument, admittedly, than with respect to the other counts. But what I would suggest to the court is that if the fact finder is finding themselves in a position where they don't credit the alleged victim's testimony on the phone, and they have a reasonable doubt then about whether the phone was taken, I think that a reasonable fact finder, there's a substantial risk, I think, that a reasonable fact finder would then have questioned her credibility with respect to the whole case, particularly with regard to the issues with her credibility that I have raised. So, in sum, Judge, I think that this was very exculpatory evidence. I think the record as it stands supports the claim. I think that it is properly brought as a direct appeal, that there was no need for a motion for new trial, and I believe that had trial counsel summoned a witness who could have testified to this fact, that it would have made a difference in the fact finder's mind as to all of the counts. And for those reasons, I would suggest to the court the trial counsel rendered ineffective assistance of counsel.
Thank you, counsel. We will hear from the Commonwealth. Oh,
I just had a follow-up.
Of course. Sorry.
We really don't know what counsel was considering, correct? Not calling the trooper?
So, a couple of things. I think that trial counsel put on the record effectively what she was thinking in terms of why there was no state police trooper, which is to say that she was assuming that the Commonwealth was going to call a state police trooper. And she found herself there on a trial date and learned that they did not call a state trooper. And at that point, she really had no remedy. And I think that that's supported by what she says on the record in terms of this is who they've called as a witness. I'm entitled to rely on that, and that she should be able to introduce it through the Northborough Police Department because that's who they called. But also, just on that point, I would suggest that the record supports that there would have been no additional strategic reasons for not calling this witness. Now, why do I say that? Primarily, if the state police trooper had anything inculpatory to add to this case, I think that the court can find on this record that he would have been called as a witness. The Commonwealth would not have failed to call a witness who had inculpatory evidence to offer. So I think that it's fair to say, and I think the Commonwealth may have raised the point that, well, maybe there was something bad that could have came out from this state trooper, and that's maybe why she didn't call her. But I think that on this record shows that that's not the case. The state police trooper would have been
no, but
called.
isn't that part of your problem? That we shouldn't be confined to this record on this issue. And for all we know, the trooper may have moved to South Carolina and was unavailable. There may be lots of reasons.
Understood, yes. I think that my response to that would have been that if that was the case, if he had moved to South Carolina or somewhere else, I think that the trial counsel would have said, Judge, I tried to get this witness in, he's unavailable. I think she would have put that on the record. And where she didn't, and she just basically implied I was relying on the Commonwealth to call him. Thank you.
Okay. Thank you very much. We'll hear from the Commonwealth.
Good morning, and may it please the court, Andrei Yanushevsky for the Commonwealth. I just want to take a second to acknowledge the victim who's watching the argument on the court's YouTube page. So, of course, as we're well aware, we're applying Safarian to an ineffective assistance of counsel claim brought in the first instance on appeal. I certainly disagree that the factual basis of this claim appears indisputably in the record when, of course, there was no affirmative evidence introduced at trial that the phone was not later recovered. Now, I think counsel's correct that it only sort of came up during this proffer at transcript page 81, but there's certainly no basis. There's no reason, there was no affirmative evidence that the phone did not come in. Counsel argued it. It's a district court case. It's true, counsel may have gotten this case the day of, and maybe she expected the Commonwealth to call a trooper. That's why I do mention in my brief that the elements of larceny do not include recovering the possession later. So Commonwealth, of course, was not required to do so.
But counsel, but if we knew that her cell phone was not found in the car. Isn't that some exculpatory evidence?
I think the defendant, of course, could have used it to say, look, you didn't find the phone, I would have had it. But the Commonwealth's reply to that would have, of course, been maybe he tossed the phone, maybe he is not.
But is it, certainly he could have tossed the phone.
Sure.
But in this context, given their relationship, is that a reasonable assumption in his taking the phone away? Isn't there a natural suggestion that he was going to go through the phone as opposed to just stealing it?
I think that's possible, but I don't know if it's more likely that than he tossed it because he hated her for not inviting him to the party the night before, for which he assaulted her in the parking lot, and maybe he wanted to destroy her phone, or, you know, there's a lot of speculation there, and I don't want to necessarily die on the deficient performance hill here, and I'm happy for the, you know, I don't think the court necessarily even has to address any of these issues, and we can move right along to prejudice.
Before we do that,
Sure.
with respect to the proffer at page 81 of the bench trial transcript, and maybe this is addressing Justice Milkey's earlier concern, is the proffer ambiguous or unambiguous in your view?
So the proffer that there was no phone recovered.
Yeah, at page 81 of the transcript. I mean, initially there's a statement, the offer of proof, Your Honor, is there's no phone. There's no phone recovered. And then I would offer of proof next that shows a cell phone that doesn't indicate what they've done with it. I'm trying to discern what defense counsel was getting at.
I think it is ambiguous. To me, it reads that there are two inventories, actually. There's a vehicle inventory that the defendant purports to attach to his appendix, but there's also a personal property inventory, it appears, that's referred to. So maybe.
Would that be a booking inventory or something different?
I would suggest, I think so, but I'm not sure.
And that is not before us.
And that's not before the court at all, no.
Now, you did not move to strike the vehicle inventory, but I take it you're still arguing that it's not properly before us?
Well, I did mention in a footnote in my brief that it should be stricken from the record. I can give you the exact.
No, I apparently skipped over the footnote.
I cite, I think, Commonwealth versus Core, SJC case, for that proposition, since it was outside the reviewable record. But I do, if the court has no further questions on the.
Reading the inventory report that is before us, to the extent we're allowed to do that, in conjunction with page 81 of the transcript, it looks like we know that the vehicle inventory report is actually inaccurate, at least to the extent it purports to say what was found either on his person or within the car. Because counsel's statement seems to say that a phone was found, even though not mentioned.
Well, I think the report that's attached to the appendix is the vehicle inventory report, which doesn't.
No, I understand the way you're harmonizing this, but.
Oh, okay.
But my point is actually that viewing that document, it doesn't contradict that a phone may have been found on his person.
That's true. That's true. But of course, again, we don't know which phone that was.
Actually, the inventory report does not state that a phone was found, as far as I can tell. I'm looking at it now. It's at record appendix
Which is
page
my
10.
point.
It does not state that a phone was found. It lists a phone charger, but does not list a phone.
So the record appendix in page 10 that I submit should be stricken, yes, that's because that's the vehicle inventory report. And so I'm not suggesting that the phone was recovered. I'm saying.
Based on the proffer, there may have been reference to a different inventory or some other information that a phone may have been found, or that.
Yes.
May have, but that's unclear.
But that's unclear. And that's why I think, frankly, the court can avoid addressing many of these issues if by going straight to the prejudice prong, because it's quite clear from the record there was no prejudice in this case. So, notwithstanding the defendant's attempt to relitigate the victim's credibility on appeal, the case was extremely strong. We have the victim's testimony to the details of the assault, disinterested witness, Andrew Killeran, who corroborated placing the defendant's vehicle there, the defendant there, the victim exiting the passenger side of the car. I would submit that it isn't quite clear on the transcript. I read what the defendant cites for that she exited the car, came back around, and rolled down the window. Frankly, I'm not quite sure. I don't quite follow that paragraph. I think if you read it in context, it doesn't make sense. So possibly the witness was confused, but regardless, that was a question for the finder of fact here. I would note that the injuries were observed. The victim testified that he took the phone. He did not give it back. He got in his car. He drove away. It was her phone. She was on it immediately prior to the assault. So I think the finder of fact could, of course, credit that.
And the defendant was able to argue.
Absolutely. So, right, exactly. The defendant made those arguments, I think, both at the required finding motion and in her closing. And then I would also just note Judge Madouse's comments just prior to sentencing the defendant. He fully accepted the Commonwealth's witnesses. He found the victim to be incredibly credible and said, "I believe you." And so I really think that any of these purported factual discrepancies were resolved in the Commonwealth's favor appropriately at trial. So in sum, there's really no serious doubt whether the verdict would have been the same had the inventory report from a state police officer been presented here.
How does the fact that this was a bench trial factor in, if at all?
Well, so the judge, of course, is presumed to correctly apply the law or instruct himself on the law. I think maybe, I don't know if it makes frankly, that much of a difference in this case. But he was there. He observed the witnesses. I think just as a jury would do, perhaps he may have paid more attention or may not have. Frankly, I'm not sure if there's anything I could think of off the top of my head that would weigh in the Commonwealth's favor or the defendant's favor stronger by having the bench trial. But certainly he was entitled to, he observed all these witnesses firsthand, their testimony, the defendant's arguments. He was made aware there was no phone on the record, even though no evidence of that came in, and certainly didn't find that particularly persuasive. So if there are no further questions, the Commonwealth would rest on its brief.
Thank you both very much. The case is submitted. And our next case, and the last one we're going to do before a brief mid-morning break, is Commonwealth versus Taft, 2022 P. 623.
Good morning. May it please the court. Rebecca Kiley on behalf of HASAN Taft. I've briefed several issues. I would like to begin by focusing on the sufficiency issues in the case. But before I do, I just wanted to remind the court that Mr. Taft has a consolidated appeal here of the denial of his motion to stay in the single justice session, which I hope to get to briefly before the end of my argument. Turning to his sufficiency claims, there are two. One is a general claim that goes to all of the convictions in the case, and the second is about his knowledge that the gun found in the case was loaded. Taking up the general issue first, this is a constructive possession case, so of course the Commonwealth was required to prove not only that he knew that the gun was under the hood and that he had the ability to control it, but also that he intended to do so. I suspect we can all agree that the worst evidence for Mr. Taft in this case is the police testimony, which, credited as it must be under the Lattimore standard for your review here, was that when police approached the hood of the car where the gun was located, that he attempted to flee. And the trial prosecutor used that to argue, and I would agree that it does this, that it establishes that he knew that the gun was there. And coupled with the fact that he was the driver of the car, that also shows that he had the ability to control the gun. But it falls short of showing that he intended to do so. On that requirement, the Commonwealth didn't present sufficient evidence. This is not a case where there was any evidence that he was involved in a gun crime. This was a traffic stop for speeding. There was nothing that connected him to the gun found under the hood or to any other gun. He didn't have any ammunition on him or near him. He was not wearing a holster. He was not particularly proximate to the gun, right? If it was going to be in the same car as him, it was about as difficult as it could have been for him to get to it.
Well, a connection is having control of the vehicle and being in a position where he could gain access to the gun. Is that not fair to say?
I think that is fair to say, but I also think that Romero made clear that that is not enough, right? That the tolerance, the mere tolerance of contraband in a car by the driver, in Romero, by the owner of the car, is not sufficient to establish possession.
Romero's an interesting case. Did I interrupt you, Judge Smith?
No, no.
Okay. Romero's interesting because I think the language of that case is obviously very helpful to you. I think where Romero is distinguishable is there's a concern in that case, if I have the facts right, that the passenger, I think, at some point handed the gun, viewed in the light most favorable to the Commonwealth, the passenger handed the defendant the gun, defendant possessed it at some point, gave it back, so the defendant clearly knew about it. But I think the court's underlying concern is this really could have been, and arguably was, the passenger's gun. That's not really the situation here so much.
Right, and as this court has said repeatedly, precedent is an imperfect guide in these highly fact-bound possession
It's really
cases.
hard finding a case that's factually very similar to this case.
Yes, although I think my best case is probably Commonwealth versus Frangillo, where there was, unlike this case, but I think perhaps kind of standing in for the flight evidence in this case, there was evidence that the defendant was involved in a gun crime, right? He was suspected of a shooting and police were investigating it. And in the course of their investigation, they found in an apartment that he was, I think, more connected to than Mr. Taft was to the car here, right? There was evidence that he had spent lots of time in the apartment, including when his fiancée, who was the resident, was not there. There were guns in 2 different closets in that apartment. And this court said he had to have known about it, he could have controlled them, he had the ability, but this doesn't suffice to prove that he intended to.
After the police found the gun, and I'm not sure he was formally arrested at that moment, but he was certainly in custody, they asked him, do you have a license? And this is according to the trial testimony, and he answered no. Where you don't challenge this, there was no motion to suppress his statements that I'm aware of. Why isn't his answer to that question some evidence that he owned the gun? And before you answer that, let me say, this reminds me of a famous joke in the movie The Pink Panther, where Inspector Clouseau says, does your dog bite? And the person says no, and the dog proceeds to bite him. And I thought you said your dog didn't bite. That's not my dog. What makes the joke funny is that a reasonable person being asked, does your dog bite, would assume that they assumed that this was his dog. Why doesn't the answer to the question, I don't have a license, suggest that he's admitting that it's his gun?
Well, I think for 2 reasons. One is that the question wasn't, is this your gun? Obviously, the question was about whether he had a license, but also and I haven't reread the transcript in this particular for a bit, so I hope I'm getting this right. But I believe that what happened was that Officer O'Loughlin did what the Boston police typically do.
I'm sorry, I didn't hear that.
That he did what I think police typically do here because of a case whose name I can't recall right now, but he demanded his license for the firearm, right? He said, show me your license for a firearm. He demanded it. I think, and forgive me if I'm misstating, and that Mr. Taft responded that he didn't have one. And I think that distinction does matter a bit, right? I think there's a difference between you're being arrested, the police says, give me your license, and you say, I don't have one, as opposed to the police asks, well, do you have a license for a firearm? Which I think might more naturally prompt the response, it's not my gun. But I also think he had to answer that question. He didn't have to answer other questions. I think it is fair for him to rest on his right to remain silent in this context, and that's what he did. I would like to just briefly address his connection to the car because it is not as strong as the Commonwealth suggests.
Before you do that, did you finish your discussion of Frangillo?
I believe I did.
Okay, you may continue then.
I hope I did. This car, at best, what we can surmise about this car is that he borrowed it from someone who may have been a relative, and that he had been in it once before.
Not that he had driven it in the past.
He hadn't driven it in the past. There was no evidence of that.
There's no evidence that he had driven it.
Contrary to the Commonwealth's brief. And Officer O'Loughlin didn't testify about how many times he had seen him in the car. He didn't testify about how recently it had been. And he didn't testify about what the relationship was between Mr. Taft and the owner of the car. The Commonwealth didn't ask any of those questions. So it's not a reasonable inference that this was a shared family vehicle. This is nothing like the kind of exclusive and continuous operation that the court found significant in Commonwealth versus Craps. So I just submit that that doesn't get them the rest of the way there.
I have one more question on this issue. And although first I'd like to take the rare opportunity to correct Justice Milkey, which I almost never have. The correct movie site is The Pink Panther Strikes Again. It was the third in the series, but rarely do I have such an opportunity. But in any event, would you agree that when you look at factors that tend to show knowledge that can go to consideration of that element, there's overlap with the factors that tend to show indicia of intent?
Yes, and I think it's hard to tease out the distinction, but I'm not aware of a case where as little as we have here was considered enough to establish intent to control and not just knowledge. And I think it is important that the court continues to affirm that those are separate requirements and they each require sufficient proof. I'd like to turn, if I may.
Before you do, I'm sorry. On that very point, I'm sure you've read a case cited by the Commonwealth, the Summers case.
Yes.
How would you distinguish that point you just made about intent and knowledge and the holding of the Summers case with the facts before us?
Well, I think there is more in Summers than mere presence in the car plus flight, right? In Summers, we had the fact that he was particularly proximate to the backpack that was in the back seat with him. He was the sole backseat passenger. It was on the floor next to him. His cell phone was on the seat next to him, which the court said gave rise to the inference that he controlled the backseat area. We also had.
But before you continue, those are the facts of Romero. Gun is right near him in his area. I mean, similar.
Well, except that.
Let me rephrase that. The proximity issue would have been the case in Romero, correct?
Yes, although I think meaningfully distinguished by the fact that a different person was holding the gun in Romero. But there's more in Summers. There is also, the court inferred from the driver's conduct in Summers that the driver knew that the gun was there and also knew that it was Mr. Summers' gun. And the court also referenced the fact that the front seat passenger also told the cop, like, hey, check out the backpack, and drew an adverse inference against Mr. Summers because he was the only person in the car who was trying to get away from the backpack, who was distancing himself. And before the flight, there was the elaborate ruse to try to get away.
Can't you say the same thing here in terms of the fact that the defendant was the only one who reacted when the latch was popped? He stood up and said, "What are you doing?" And then when the hood was opened, he's the only one who took off. Doesn't that create a similarity there?
Well, again, I think it creates a similarity, but we still don't have the other factors that I mentioned, the proximity and the behavior of the other people in the car.
But there is proximity to the lever, which was needed to access the gun.
Sure, but it's not easy for him to access the. Right, I think keeping the gun close to him in the car would be more suggestive of an intent to control it.
Yeah, but I mean, this may be a weak analogy, but isn't that like finding someone with a key to a safe in which there's a gun?
Well,
You're the only person who can access the gun.
He's the only person in that moment. We have no idea how long the gun has been there or how many people have driven it. He's not the owner of the car. So it's certainly not like being the owner of a safe who holds the key.
Can we turn to the knowledge issue? Excuse me, the knowledge of it being loaded.
Yes, please.
Issue, because let's just say hypothetically, we were to disagree with you about intent to control the gun.
Yes.
How much daylight is there between that issue and the knowledge that the gun was loaded, where anyone who would have handled the gun could have seen that it was loaded?
I think there's quite a bit of daylight because there is no evidence in this case that he handled the gun. The Commonwealth did not prove that. It requires speculation.
But if he knew it was there and intended to control it, isn't there an inference that he placed it there?
Not an inference that can sustain a conviction beyond a reasonable doubt. If he knew it was there, and I understand I have to concede that he did, we have no idea why he knew. He could know because someone told him, because they hinted it or implied. He could know because he saw it. He could know because he saw the person put it there. But to know that this gun was loaded, you had to handle it, right? You couldn't know by looking, even if he had seen it under the hood, and there's no evidence that he did, but even if he had, he couldn't have known that way, right? The photo makes it clear you can't see that slide indicator in the photo. And not only that, Officer O'Loughlin, who's trained in handling firearms, he didn't know that the gun was loaded when he found it. He had to be told later on by the detectives in the case. I think this requires an inferential leap that is too far to sustain the Commonwealth's burden of proof beyond a reasonable doubt, to assume that he is the person who put the gun there.
Time is getting short. Would you like to turn to your other issues?
Sure. Well, before I do, I would just like to mention on the issue of the stay, he filed a stay motion in the trial court and in front of the single justice. He wraps his mandatory sentence in February and will begin the 6-month consecutive sentence after that. He's not interested in being released if there's a chance that he's going to have.
I'm sorry,
He's not interested in being released at this point if there's a chance he will have to return to finish his sentences. But I would ask that if the court is inclined to grant relief on either of the sufficiency claims, that you please consider allowing the motion to stay, reversing the denial of the motion to stay on the relevant sentences so that he doesn't serve any more dead time than he already has. On the remaining arguments, just briefly, there are a number of them. I think the biggest issue with the closing argument was the prosecutor's repeated claim, which actually began in opening. It was the theme of the closing, of the entire prosecution, that what he had to prove was that the gun met the statutory definition of a firearm.
Do you have any case in which a judge properly instructed the jury on a point of law where the prosecutor may have misstated what he or she needed to prove, that it was reversed on that basis? So the jury was properly instructed, but the prosecutor made some misstatements.
Off the top of my head, I don't. And this was made, I'm making this argument in combination with the other errors in the case. And so I think that would be the appropriate thing to look for. But I don't know of a case specifically only on a misstatement with a correct instruction. I would note the correct instruction came before the repeated incorrect argument, right? It ran throughout the closing, and it struck directly at the biggest weakness in the prosecution's case, right? He absolved himself of the thing that was hardest for him to prove. I see that my time is up, so I think all I will say about the remaining issues is that I would ask the court to consider, when you look at them, that this was a close case. This jury deliberated for 10.5 hours in a case where the presentation of the evidence, I believe, took 6 or 7 hours. They took it very seriously. It was hard for them. They clearly saw it as a real credibility contest between the police and Mr. Porter Elder and gave serious weight to the defense presentation in the case. It was the only thing his credibility was the only thing that they asked about during their long deliberations, and I think that's a factor the court can consider.
Before we let you go, I know I have some questions, and I believe at least one of my colleagues does. On the Second Amendment argument, are you really saying that Bruen answers this question, or is it more that the Heller-Bruen line of cases supports an argument that the Massachusetts licensing scheme is unlawful?
I think Bruen leaves no escape hatch for the licensing scheme as it is construed in Commonwealth versus Gauss. So I guess I am saying it is controlled.
And if a court is to ever reach that issue, isn't this the wrong case to do it in, where trial counsel stood up at trial and said, no, there's no issue here?
Well, I think this is similar, as I argue in my brief, to the post-Melendez-Diaz Vasquez decision, in which the court recognized that because the case law was so clearly settled in the Commonwealth, because any objection would have been futile.
But it was also, according to the Supreme Court, clearly established to the contrary in their case law. And I hear what you say, that you think Bruin is absolutely inconsistent with this, but I'm having a hard time seeing that. So were the Supreme Court to reach this issue, even if they ruled in your client's favor, I don't see them saying, this has long been established that such licensing schemes are unconstitutional, where this was not the same issue
Well,
in
the
Bruin.
issue is not the constitutionality of the licensing scheme. The issue is the due process violation of telling the
The
jury
issue
that
is whether or not it's an affirmative defense that you
Right.
don't have a license. And that was not the issue in Bruin.
Right.
Okay.
But it's not even a due process, as Gauss covered the due process, but it's a Second Amendment. Is it not? The finding that, again, Heller was interpreted to confine the right to bear arms and self-defense to the home. And that's the grounds that Gauss dispatched with the Second Amendment claim, correct?
Right. So I think that what I'm making is a due process claim that is predicated on the Second Amendment decision in Bruin, right, which is the only thing that distinguishes Mr. Taft's conduct from perfectly lawful, presumptively constitutional conduct is the fact that the Commonwealth alleged that he didn't have a license. And if that is the only fact that makes this a crime, it has to be alleged and proved beyond a reasonable doubt by the Commonwealth. And you can't have the judge tell the jury, put this out of your minds, ignore it. Without creating a
I understand the
process
argument. My point is, this may not be the case to raise that argument.
One last point. Isn't the distinction, though, that after Bruin, that, again, this occurred outside the House, where the Gauss decision really relied upon the fact that Heller was inside the abode, where
Right.
the Gauss facts were outside the abode.
Yes, I think that's why Gauss is no longer good law after Bruin.
Okay, one last question from me. I lied before. On the motion to suppress, you seem to be not challenging the existence of probable cause, correct?
That is correct. And I thought I made this clear in my summary of the argument. I presented that issue in this brief so that should the case ever get to the SJC, it could be considered. I'm not asking, in that case, I'm not asking the court to do what I know it
Understood,
can't
and
do.
I assume that's why you didn't affirmatively raise it at oral argument.
Yes.
Okay. Thank you very much. We will hear from the Commonwealth.
Good morning. May it please the Court. Ian McLean on behalf of the Commonwealth, and along with me at counsel table is the trial prosecutor, Frankie Leone. Your Honors, there was sufficient evidence here to establish the constructive possession of the firearm. You've pretty well covered it already. This case is as analogous as we're going to get with this unique situation of the gun underneath the hood. It's as analogous as we're going to get as Summers, I think. I didn't find any cases that ever involved guns placed under the hood before. I think it's an interesting approach that this defendant has taken to try to distance
Would the
himself.
Commonwealth acknowledge that this is at a minimum close?
Yes, Your Honor. Yes, Your Honor. But I do think that we do survive and clear the threshold here. You've already pointed to several of the analogous reasons from Summers. What we have here is not mere presence. We have presence plus other incriminating factors in addition to the flight. We have the proximity of the weapon through him being the sole person to access the release valve for the hood, the release latch for the hood. So despite the fact that he couldn't reach underneath his seat and grab the weapon, he was the person situated most proximate to this weapon in a place where he was the sole control of the access to it. And while I hadn't thought of it, I kind of like your analogy of the person holding the key to the locked safe. We would just add into your analogy to make it more factually accurate here that the holder of the key was then found standing right next to the safe. That would be the closer analogy to what we have here, where he's the person, the sole person sitting next to the release valve to open the hood to access the weapon.
Now, you didn't make anything of my Pink Panther argument. Having heard my statement and Ms. Kiley's response, how would you
Having only seen the original, I'm not sure that I'm in a position to comment on the subsequent movies, but I'll wait for the franchise to be rebooted in the near future, as Fletch has just been rebooted. I assume Pink Panther's right around the corner. Turning to...
I want you to forget the analogy.
All right.
Can anything be made of the defendant's response to the demand as to show a license?
I think, yes, it can, Your Honor, but I would say yes, it can go both to knowledge and intent there. The inference might not be incredibly strong, but it is a valid inference to draw. As opposing counsel mentioned, the defendant then exercised his right to remain silent. He could have exercised his right to remain silent throughout.
Well, I mean, the cases draw this interesting, subtle distinction between an inquiry and a demand that I, for one, have a hard time following, but this may explain why there was no motion to suppress the response to the demand.
Yes, Your Honor, and I just don't remember from the transcript the word that was used.
Demand is the transcript.
Was used was demand. I would just point the court back to the flight. His escalation of behavior as the officers got closer and closer to where the firearm was stashed as much stronger evidence of his knowledge and his intent to exercise dominion and control, as evidenced by the fact that he was the person that sat in the driver's seat that had control of the latch to release the hood. And as the officers during the inventory search moved closer and closer and then moved into a probable cause-based search and grabbed the latch, that's when his behavior drastically changes.
And all that shows knowledge, correct?
Yes, but as pointed out before, frequently facts overlap and can be used to contribute to both of the two portions of the test, knowledge and intent. And here I think the facts do overlap here, and you can draw an inference on his intent to exercise.
Well, how about then turning to the knowledge that the gun was loaded?
I actually have a question about that. Does one need to have had handled a gun in order for there to be proof of intent to exercise control and dominion?
Absolutely not, Your Honor. Absolutely not.
Here there is no evidence that the defendant handled the gun, correct?
Not at trial, no, Your Honor.
So how do you satisfy the knowledge element of 10N?
By the way that the weapon was placed and by him choosing to see, as you can see in the record appendix, pages 47 to 49, the way the weapon was placed in the hood compartment next to the battery with the handle.
But if there's no evidence that he handled it, how do we know that he saw it placed in there?
It's a reasonable inference, Your Honor, from the fact that the way that the weapon is placed in there in a manner such that it could be accessed easily for then use. So there's a reasonable inference that he then was aware of the fact that the weapon was loaded. When you add in the fact of the indicator bar on the top of the slide, as the jurors had the weapon
It
itself.
presupposes that he either handled it or had someone tell him that it's loaded.
Or looked in there,
or looked and saw it.
Correct, Your Honor, from a vantage point different from the vantage point at which the photographs were taken.
Strikes me, and certainly haven't made up my mind on this, and I can't speak for my colleagues, but it strikes me that that's close to speculation, if not outright speculation.
Well, I'd disagree with you, Your Honor, and I'd say that we do have to look at the evidence in the light most favorable to the Commonwealth and draw all reasonable and possible inferences in our favor. It doesn't have to be a necessary or an escapable inference, just a reasonable and possible inference.
But how strong an inference is it that the gun was placed so as for ready use? Because I'm looking at the picture, and yes, it is, at least once you open the hood, it is readily accessible, but it's hard to imagine how else the gun could have been secured under this hood. So I'm not sure how strong an inference can be drawn.
Well, respectfully, Your Honor, I'd say there are several places underneath the hood of a car where you could stash a firearm. This firearm was stashed in such a way that the handle was placed where it was placed, that the weapon could be grabbed and drawn. It's almost as if it was...
There's not a lot of room in this space.
From that close-up view, Your Honor, from the close-up view of where this gun was particularly stashed, it's almost stashed as though it was in a holster seated next to the battery so that it could be drawn immediately and used. And unfortunately, this evidence didn't come into trial, but I mean, as you know from the motion to suppress hearing, there was, and the entire reason why the officers had probable cause to search there is because this vehicle was suspected to have been involved in a shooting where a witness saw someone run back to the vehicle and place something underneath the hood, close it, and drive off. Didn't come into trial, so it's actually not part of our consideration here, but it sort of informs why the weapon was placed there the way it was placed there, and as the prosecutor argued, in a grab-and-go manner. So I think this defendant was smart enough to realize, and you can infer from his behavior during the inventory search, that what would happen during an inventory search of the interior of the car or a frisk of the vehicle in a
But
stop situation.
in terms of the placement here, I mean, true, if he's standing in front of the car with an open hood, he can grab it quickly. But that's not a great, easy access if you got to stop the car, pull the hood latch, run around, then grab it.
Well, if your
So
car-
why couldn't it simply have been stored there? Because he knew that he might be stopped and didn't want it to be in the car.
Well, I would say that it's stored there in part for that reason. And you can infer that from his behavior during the inventory search. He didn't change his behavior, he remained calm throughout the inventory search because he knew full well the weapon was not going to be
No,
discovered there.
that shows he hid it there, but it doesn't show that he knew it was loaded.
Right, Your Honor. It doesn't show that he knew that it was loaded, but the manner in which it was hidden there, such that it could be easily drawn and then used immediately, from that you can infer his knowledge that the weapon was loaded. And you can look at the cases that talk about the external characteristics of the weapon, the revolver cases, or the case of Cassidy, the extremely large capacity magazine. From looking at the weapon itself, you can tell that it's loaded. Also, those cases in somewhat talk about where they're storing the weapon itself. From that, in a manner that it could be easily drawn.
How do you address the testimony from the officer that he had no idea personally if it was loaded and he was told it was loaded?
Because officers at the scene don't recover firearms. So he sees the weapon, and what happens immediately thereafter, raises the hood, sees the weapon, the defendant stands up and starts running off. So now we're involved in securing the scene. He's not doing a close inspection or examination of the weapon, and that's not his role. As is his role, he contacted a district detective to come out and collect the weapon.
But based on what he would have seen in terms of the gun in there with just can you tell that the gun was loaded? So if he had seen this gun there, could he have, without handling it, have known that the gun was loaded?
From his vantage point where he saw the gun, he could not tell that the gun was loaded. But that doesn't mean someone had looked over the weapon closely as they placed it in. From his vantage point of lifting the hood, seeing there was a weapon there, seeing the defendant then run, he wasn't focused on the details of the weapon that he saw underneath the hood at the time. And after the defendant was apprehended, he wouldn't be focused on the details of the weapon because it's not his role.
There's no evidence that the defendant looked at it closely either. I mean, I think if you can infer, I guess, that the defendant handled the gun and placed it there, if that's a reasonable inference, then you get to a reasonable inference that he knew it was loaded. But if you can't make the first jump, I don't know how you get to the second point.
There are two ways to get there that him having the knowledge. One is the inference that he placed it there himself. The other is that someone else placed it there and informed him that it was placed there. Now, if the manner in which the gun...
And if it's the latter, then we can't assume that he knew it was loaded.
The manner in which the gun is placed there, such that it's easy access for that grab and go or ease of use when the vehicle is parked and you're standing next to it and able to access it, not when you're driving down the street. But the manner in which it's stored, that's how you can infer the knowledge that it was loaded. It's almost as though it was a holster that was placed not immediately on his body.
I understand the argument. I'm just having a little difficulty with how reasonable the line between inference and speculation, as with all these cases.
Understandable, Your Honor, and that's the nub of this case, and whether that charge survives this case here.
So there's a relationship between access and intent, and you cited against Summers. And as Justice Milkey asked you, this wasn't a gun right near him. He would have stopped the car, popped the trunk, get out of the car. This wasn't ready access, where in Summers it was. In Summers it was also proximate to the defendant. And in Summers it was in a backpack, which is different than a vehicle, or could be considered different from a vehicle. How do you distinguish, or how do you not distinguish? How do you find that Summers controls the facts in your case?
I wouldn't say controls. I'd say analogous to. And I say Summers is about as close as we're going to get, simply because I've never seen a case with a gun was stashed or stored underneath the hood. And it's a fairly clever idea for the fact that an officer wouldn't normally discover that in an inventory search or a frisk of a vehicle or something. So I'd say that the comparison between the gun in Summers being in a backpack versus being in the hood here is that the gun is out of sight and stored in a way where it won't immediately be discovered. Now, then the proximity in Summers is sitting next to the backpack. The proximity here is the latch is right here, where I'm seated as the driver. I'm the person that has the most proximate relationship to the weapon where it's stored, next to the battery on the driver's side also, I'd point that out. So it's not controlling, it's just that it's analogous and that the weapon is concealed and the person that was charged was the person with the most proximate access to the weapon.
One last question for me, I believe, on this issue as well as, in your brief, you write that Officer O'Loughlin had seen the defendant driving the Snot on prior occasions. That appears to be a mischaracterization of the evidence.
At this point, Your Honor, I would acknowledge that it's at least an overstatement, Your Honor. He did refer to a single incident, and I pluralized it, and I should not have done that. My understanding of his testimony was he's saying that he had seen him driving the vehicle before.
I don't see that anywhere in the record.
So then, if that's an overstatement as well, then I apologize for arguing that it was more than the officer actually testified to.
And again, that's a fact that would matter, his control over that vehicle. That would weigh in whether or not, if he had continuous control of that vehicle, for instance, that would weigh more heavily for him having intent, knowledge, possession, constructive possession of that weapon. Is that fair to say?
Absolutely, Your Honor, absolutely. But I would, again, point the court back to his escalating behavior during the stop. He did immediately try to distance himself from the situation by providing false identification. And then after he admitted that he had provided false identification, he was very calm as he was exited and an inventory search was conducted. Again, establishing his state of mind, his knowledge that, oh, this is just an inventory search of the interior of the car, they're not going to find the gun. When the officers then move towards the latch, his behavior immediately changes.
Understood. I think as counsel referred to, it's difficult to tease out the line between intent and knowledge. Knowledge is very secure, and all these issues or factors you're listing go to knowledge, and that's not in dispute. I think the question is intent.
Absolutely, absolutely. As opposing counsel conceded knowledge at the beginning of our argument, but I think a lot of those facts that contribute to knowledge also contribute to intent. Not as strongly, but they do contribute to intent here. When we look at all this evidence in the light most favorable to the Commonwealth, and we draw all those reasonable and possible inferences, again, they don't have to be necessary or inescapable, just reasonable and possible, then there's enough to survive here, in this case. Unless there's any other particular of the issues you wanted to discuss.
Yeah, I have a question on the closing argument.
Sure.
The author of your brief apparently shares my love of movies and cites to the movie Old School for the reference to referring to someone as his boy. It's a creative citation, but doesn't that actually undercut the Commonwealth's case in that what makes the joke funny, to the extent it's funny, is the fact that Will Ferrell is referring to an 80-year-old white man as his boy, which is not the context here. At a minimum, shouldn't the word have been avoided in this context?
No, Your Honor. And I think the way that you're interpreting it is incorrect as a matter of pop culture. The expression "my boy" is a way to say it's a current vernacular for saying "my close friend." That's what it is. The slang term has just come to mean that.
But that's not what makes it funny.
That's fine, Your Honor. I suppose we can disagree about what it is that makes it funny. It's not the reference to a boy having to do with age versus an 80-year-old man. The reason that it was cited here is because of opposing counsel's reference suggesting that it was a racist-based comment. And
Can it not be interpreted as such, is my point. I'm not saying it was intended as such.
The way it was used here? Absolutely not, Your Honor, because the comment was, Mr. Taft, that's his boy, his buddy. That was the comment that was made in closing argument. It's clearly a reference to people that are of comparable ages that were spending time together driving down the street in a car, and now that person is coming to testify on behalf of the defendant. It was a reference to him being close friends with him, which is a comment on assessing his credibility, which is absolutely something a prosecutor is entitled to do in a closing argument. And as opposing counsel pointed out, that the argument they were actually making was the contrast, primarily the contrast between talking about police officers being neutral versus the defense witness having a bias. And I would point out here that a prosecutor is entitled to make an argument about credibility, but this jury was reminded by the judge on multiple occasions they're the sole arbiters of credibility. What he was doing was pointing out you should assess these things when assessing their credibility, the personal relationship between the parties here. And that's an appropriate argument to be made in closing. Unless there are any questions that you wanted to address the Bruin claim or?
I was going to suggest a Bruin claim, but I have no question. I was going to wait to hear the Bruin claim.
Okay.
Yes.
So I would say that the defense argument overstates significantly the holding of Bruin. What I would point to is within Gauss, they refer back to a case, Lodholt. It's quoted in Gauss. And the quote, it's a 10H case there, so it's within the home. It's a lack of an FID card there because it was a 10H case. But the quote that the SJC ended the case with is, "Nothing in the McDonald and Heller decisions has altered or abrogated the state of the law concerning the statutory presumptions." So that was a case inside the home, which would have been controlled by the changes in the law from Heller and McDonald. And there the SJC said nothing about those two cases changed our presumptions for FID card inside the home cases. So you take that same argument in Bruin now where we have the same right outside of the home, the same reasoning from the SJC and Lodholt applies now. Nothing in Bruin alters our law about assigning the burdens for the presumptions, assigning the burdens for the affirmative defenses. So that's what I would say. As the appeals court, we're stuck with that. So maybe the SJC is going to revisit this at some point in the future, maybe not in this case because of the way this case will present it. I mean, the Guardo case is there under advisement right now where they did discuss this. The only thing they didn't really address in Guardo was on the due process prong when they're talking about the burdens imposed on placing the burden on one side or the other.
So was this issue raised in Guardo, however you pronounce it?
In the initial briefing, no, but then there was a motion to rebrief, and they rebriefed it, and so they did rebrief the issue, and it was argued. There was not much presented on the due process prong, this last piece that I'm talking about. How much burden would it impose on the defendant to raise the defense, or how much burden would it impose on the Commonwealth to accept this as an element?
So in a case argued before a different panel yesterday, both counsel apparently asked the panel to stay that case until the SJC ruled in Guardo. You're not asking this?
Not necessarily, Your Honor. I mean, I think it would be a perfectly reasonable decision for you to stay the case, but we didn't seek a stay because of the way Guardo presented. It seemed likely that they were going to decide the case without addressing or reaching the Bruin issue. So if you do decide to reach it here, the one thing I would just like you to factor into that, assessing how burdensome it would be to impose this on the Commonwealth, is a statute that hasn't been referred to before, the safe harbor provision, 140, 129C.
Counsel, without purporting to speak for my colleagues, I would be very surprised if this court were to resolve the Second Amendment issue before the SJC or the Supreme Court did.
All right, thank you very much.
I will leave it there.
Unless there are any further questions.
Hearing none, thank you both very much. Very interesting case, which is now submitted. We will take a short 10-minute or so break, and we will be back to hear first the source. Barely. We're back on the record for our next to last case on the docket, DORIS-GUSTIN versus Deutsche Bank, National Trust, and another, at 2022 P81.
Good afternoon.
Welcome.
Thank you for allowing me to speak to you.
Could you just tilt the microphone in your direction? Yes, thank you.
I am a tad nervous, so if you could bear with me. I am not a lawyer, but I did sell real estate in West Roxbury and Dedham for 25 years. And during that 25 years, I explained registered versus recorded land to buyers and sellers. And we always felt that registered land was the better way to go. Today, as it was when the Torrance system was first implemented in Massachusetts, all of our I's need to be dotted and our T's need to be crossed. However, this has not fell well with our mortgage companies, with their institution of the MERS systems, and I will acknowledge that all of our courts seem to be overwhelmed with MERS cases. What we did in our pleading is we removed all of the cases that had to do with MERS, and we just dealt with Massachusetts cases. In this case, we discovered that the assignment of mortgage from H&R Block to Auction 1 was, we cannot confirm that the item was ever notarized. We wrote to the
Counsel, can I just stop you? Because the issue before us today is, how is this case any different than the case that was already resolved by a different panel of this court? And I see that here you're relying on a case that apparently was not cited before, Allen v. Allen. Other than that, what is different? How do you, in colloquial terms, how do you get a second bite at the apple here when this court has already heard your arguments, ruled against you, and...
I feel that Judge Spicer, we've asked him to review his finding on the very first argument that we made, which was having to do with the notary. And he never really answered the question. And so, but everybody has hopped on saying, oh, he did, but he never did. And so if you looked at page 5 of his writings, he does this void versus voidable dance, but he never answers whether or not the assignment is void. And that's what I keep talking about.
No, but why didn't the ruling by this court answer that question and say it was voidable, not void? And that you, where it was determined to be voidable, they further concluded that you did not have standing to raise that issue. And why didn't that resolve this litigation?
I don't think Mass law has any talks about voidable, anything being voidable. With the laws that we have currently, it talks about just being void. And under Torrance, if it hasn't been acknowledged, and this has not been acknowledged, as with the Allen v. Allen case, then it must be made a fiction. And when we keep going back to Judge Spicer, he keeps saying, I've already ruled on that. We don't think he ever did. I don't think I'm answering your question, though. I was not here at the first argument. I wasn't here at the first argument. My lawyer came in and argued it, and so I have no idea what he said.
But the overriding point isn't who argued it, it's the fact that arguments were made on your behalf. A different panel of this court considered those arguments and ruled against you. And so the question is, why isn't this case over? I mean, it's a basic principle that you don't get to argue the same issues twice.
I don't know if they ever argued that Judge Spicer was wrong. I think he was confused. He cites not the first assignment, but he cites the second assignment as being the one that was argued. And the assignments were put in, they were written out of order. And I think that has caused a lot of confusion with the courts. So, I guess I'm not sure what my first attorney said. I do feel that Judge Spicer did not answer the question that we asked, which was the assignment void? We have proof from California that it was not recorded in the notary's journal as it's supposed to be done here in the Commonwealth as well as in the state of California. So can you take something that would be void and make it voidable and then therefore viable? It just doesn't seem to make sense to me. So that's why I've come here today, instead of just letting it sit. I know opposing counsel is going to say this has been litigated to death, but I don't think the original question was ever answered, and that's why I've come back.
Okay.
And being there is my favorite Peter Sellers movie.
And I will agree with that, except for the microphone you can see in some of the scenes. I understand you're splitting your time, and Mr. Williamson will
Correct,
be
Your
on
Honor.
first.
May it please the court, Christopher Williamson for Deutsche Bank National Trust Company as trustee for the certificate holders of Soundview Home Loan Trust, 2005 OPT4 Asset-Backed Certificate Series 2005 OPT4. Sorry, I had to say the whole thing. Essentially, the only issue we're here on is whether the land court abused their discretion in denying the motion for reconsideration of the appellant's motion to reopen the case, filed 3 years after judgment entered, filed more than a year after this court affirmed it, and filed more than a year after the SJC denied further appellate review. As it stands now, we're over 4 years from the original land court judgment. Yet, we're still hearing the same arguments that have been rejected by the land court 4 times, have been rejected by this court, have been refused to be reviewed by the SJC, and that the housing court in the following summary process matter didn't address. To the land court's credit, they addressed the motion to reopen under Rule 60B. In their analysis, they determined that under subsections 1 through 3, the motion, regardless of what was stated within it, would fail because it's more than a year has passed since judgment is entered. Regardless, they looked at the actual issues being raised in the motion. One was this notary issue, which has been at issue for over a decade at this point, and held that, the court's already made its decision on that, both the land court and this court, that the assignment involved with the notary involved at best would be voidable, which would give the parties to the assignment the ability to challenge its validity, but it wouldn't give a mortgager the ability to have standing to challenge it because it wouldn't be void. They also addressed the 2012 fraud article that was included within that. In doing so, they said, one, that there's no record that this has anything to do with the mortgage at issue here, but two, that that issue, that case, that article predates this matter by almost 5 years. So how can it be newly discovered when it already exists? Essentially, Your Honor, we just really have just another attempt to have the same issues relitigated, and I don't believe there's anything in the record that shows that the land court abused their discretion in denying the motion for reconsideration. I'm happy to take any questions on the matter, but...
We understand your argument. Humor me for a moment,
Sure, Your Honor.
though, in terms of Allen v. Allen, which was not cited before, and I understand it doesn't speak directly to the void versus voidable issue, but if you could address why you think it isn't relevant.
Well, I think because this court has already made its decision on the void or voidable issue, I think there's two parts when it comes to looking at that one specific assignment. One is the standing issue, which I already talked about, and two is the actual specifics of 18354B, which the assignment must comply with. And it's a rather loose standard that it must comply with. It has to be authorized by, it has to be executed by someone who's authorized with the authority to do so, and it has to be done before a notary, which this assignment at issue was, and which which counsel for the appellants in the underlying land court matter back in, I believe, 2017, when they were discussing a preliminary injunction, agreed that the assignment at issue was facially valid. It really was just this, it wasn't, the notary issue was really the only question they raised on that specific one, and then with both of them together, the timing of registration, which I think this court has also clearly made its determination on, that under the relevant statute, it's the time of registration, not the time of execution that controls. So I think whether or not this case is applicable or not, this court's already made its decision. I don't believe it changes anything when it's so clear-cut that these assignments at best would be voidable. I don't even believe they are. I'm not sure. I don't want to speak for the court who's already held this matter, the panel that already decided whether it's voidable or not. But I think this really is just a question of whether the land court abused their discretion, which I think based on the long record of this matter, they haven't. Unless there's any further questions, I'll cede the rest of my time to my brother.
I'm not sure you can do that, but we can hear from your brother.
I just don't know if he wants to say anything either, so
Actually,
I'm just giving him
I do
the...
have a question on the attorney's fees. Was that included in your brief?
So the arguments related to why the attorney's fee should be included were the direct request was done in a separate joint motion because it was being brought by both my brother and I. I do think there is pretty good precedent and legal standard that was included in that motion for why it would be necessary. Essentially, this is a matter that involves a 2005 mortgage that became due for August 2006.
Behind my brother's question is the requirement that the request has to come in the brief.
I understand, Your Honor. I think that would be an issue where we tried to make it jointly, even though we had our own independent briefs. I'm happy to, if the court would allow me to supplement to include that within the brief, if that's something the court's looking for. I understand the situation here. I certainly told my clients that while I thought that damages would be justified in a sense that when dealing with a pro se party, that they're not always, the court's not always inclined to grant them. So I can understand if you won't give me the opportunity to amend the brief.
I didn't know we were that transparent.
Thank you.
We'll hear from counsel.
May it please the court. My name is Dudley Gore. I represent the co-appellee Option 1 Mortgage Corporation. I'm going to take your advice, Justice Milkey, from the beginning and not belabor this any more than necessary. I think my brother ably stated our position as well as their position. I just add a few other things that are perhaps obvious to the court, but nevertheless, I'm going to state them. So the procedural posture of this is an appeal of a denial of a motion for reconsideration, which is even narrower grounds for deciding than the original motion, or it was I can't remember how it was styled by the appellant, but the request to reopen the petition, I believe. So what the court is really looking at is whether there's any change in law or change circumstances from the denial of the request to reopen the petition, which there isn't. The appellant keeps going back to this void. She believes that the assignment, and to be clear, there's only one assignment discussed in her brief. The first assignment is facially void. That has been dealt with exhaustively by the briefs in the first appeal, as well as by this court previously, and it was determined correctly that there is nothing that would render the assignment facially void. But I want to also make a distinction in the term void, because it's cited in the notice of appeal as the basis for the appeal under 60B4, which does not arguably does not have a time limit, unlike 1 through 3, which has the year time limit. So, and the distinction is this, that to what 60B4 means by void means that there was lack of jurisdiction over the parties or the subject matter, for example. It does not mean that it's void because of a dispute arguing that the court made an error in their decision. That's not what it means. And so I would submit that even if at this point there was a determination, a revisitation by this court and a decision that the assignment was indeed void, that is not a basis under 60B4 to overturn that decision. That's not what void means in 60B4. I think that the appellants are time barred under 1 through 3, and they haven't stated a basis at all under 60B4. I would refer to my brief for the other arguments. I would just submit, Justice Milkey, that that case, I'm not sure for what purpose it was cited by the appellant, but I didn't address it in my brief for that reason. It wasn't it was cited but not argued.
It's an interesting case by my former colleague, Judge Katzman, and as with all of his opinions, it's very long and erudite. That's all I'm going to say.
Thank you.
Thank you all. I just need to correct myself for the record on one point. Being There is a superb movie. I would still go with Dr. Strangelove.
I agree, Your Honor.
Thank you all very much. Case is submitted. And our next and final case of the day is a sword matter, John Doe, number 389586 versus Sex Offender Registry Board. It is 2221 P1141. And I would just remind able counsel that the matter is impounded and no references to names other than, for example, experts.
May I again? Good morning, may I please the court? Attorney Fred Burkholder for Doe 389586.
Could you just tilt the mic toward you?
Yes, of course.
Yeah.
Attorney Fred Burkholder for Doe 389586. I'm going to try to be as brief as possible. I know the court's read the briefs. I want to credit my brother for basically stipulating to two of the errors that I assigned, one being that funds should have been allocated, and secondly, that application of Factor 1 should not have occurred. So the real question before the court is, what's the appropriate standard to determine the course forward? I find that to be a very interesting issue. I try to update my research before I come in to see you folks, and to my surprise, although I should have read the opinion before, should have noticed it before, there's been a decision out of this court.
Counsel, let me just cut you off. The counsel is very aware, the court is very aware of Doe number 22188, I believe.
Very much so.
So,
the decision in my hand. I think that this decision does a very good job of analyzing the difference between a sufficiency standard and a prejudice standard. I love the conclusion that says basically at the end of the day, on balance, we conclude the proper standard review is whether or not they may have affected it. I can't see how a court could not say application of factor number 1 and a determination of whether or not someone has a paraphilia or other psychological diagnosis under factor 35 is not something that's going to materially affect a decision. As a result, my argument is very simple. This is a case where remand should occur, an expert should be appointed, and then, frankly, we can get to the bottom of a lot of the questions in this case. I know that the hearing examiner didn't have to assign weights. I'm very familiar with that decision, as the court is as well. However, when you have a situation where an individual completes their treatment and is found by a treatment review panel to have done so, and yet he's given minimal weight with regards to that based upon indications of certain conduct, I think we have a dichotomy that's beyond the scope of what a hearing examiner is capable of. And I think that's the very type of case that 89230 was decided for in the very beginning. We've got a situation here where we've got a guy completed treatment. He's 62 years old, which they don't give him credit for because of his activities.
He's 66 now, correct?
Yeah, that's true. And you know, Judge, what comes back to me when I read this particular decision, which frankly is well written, the hearing examiner got to where she wanted to get to by picking and choosing and the like. My client's responsibility is not to say there's absolutely no risk whatsoever, and I referenced that in my brief. It's not his responsibility to say he's basically, you know, what's a eunuch, I guess would be the appropriate word to say that. There's no requirement that I have any burden to say that I don't have any sexual impulse whatsoever. So for me to say, when you look at whether or not there was an effect, I have to say that there was. Talking very briefly, go ahead, Judge.
No, I think we get that. Supplemented by the new case, I think we understand what your argument is.
All right.
The Superior Court found error here on the funding issue. The board appears to agree with that or concede error. We may be bound by the board's concession. We are not, strictly speaking, bound by the Superior Court's finding error. So if you will indulge us, could we discuss a little the merits of the funding issue? Because...
Certainly. I think my brief covers it, but I'll try to reference the best that I can.
Well, since the board conceded this point, let me, for the sake of argument, make the board's best case, which is under these facts, there really is such overwhelming evidence of paraphilia that an expert wouldn't really add anything to the diagnosis issue of whether or not he, at least at one point in the past, had paraphilia. And then the rest is covered by the regulations, which establish that you can take this into account under Factor 1. Therefore, it wouldn't, you know, the stuff specific to him is essentially uncontested or impossible to contest, and the rest isn't specific to him. It's the validity, if you will, of the regulation and how the regulation is supposed to operate. How would you respond to that?
I think the three cases that I cited address it. Basically, what they say is, okay, if you're going to allege that there's a denial of funds and you're going to allege that it's based upon a psychological condition, if in fact there is no psychological or no application of Factor 1, then we agree. Then we can go on to whether or not there was a prejudice versus whether there's a sufficiency test and the like. But as soon as you get to application of Factor 1, as soon as you do that, those cases clearly state, as soon as there's an application of that factor, then there must be an expert. And I think it comes down to the nature of the diagnosis itself. I mean, in this particular case, although we'd all love to say, the court would maybe love to say, okay, well, all of this is representative of paraphilia. It takes a diagnosis. And all we have here, really, and that was questioned by the Superior Court as well, was, is there even enough for a diagnosis in the first place? You've got one passing line at the very end of a comprehensive evaluation that was written in 2017.
But counsel, your client self-reported that he either, I'm not sure if this was on the voyeur side or the exhibitionist side, but that there were over 1,000 victims. Why doesn't that fairly self-evidently establish paraphilia, at least sometime in the past?
Because I don't think that's a determination that can't be made without an expert. I mean, I have a limited amount of experience doing SDP cases, and when you look at the diagnoses that are required therein, there are certain requirements under the DSM-5 that have to be met for that diagnosis to be in existence.
But in the SDP context, you need a diagnosis.
Well, but you do if you read Factor 1, it says the same thing. You have to have a diagnosis from a medical professional. And that's why the Superior Court judge wrestled with that question herself, because does that not qualify? And I frankly, when I first looked at it as well, I said to myself, okay, well, this is signed off on by a psychologist. I bet that psychologist didn't do anything other than read the notes. I'm sure there was no personal interview, there was no assessment that was done by otherwise, and the like. So we need a diagnosis. Okay, just to say all this behavior occurred, that's not what Factor 1 says. Now, I think my brother made a very, very tactical decision here and said to himself, okay, Fred's going to say that if Factor 1 is applicable, then I need an expert. So you know what, I'm going to take Factor 1 out of the quotient, and therefore he doesn't need an expert. And my response to that is, but we have a guy here also, despite everything else that's occurred, we have an evaluation in 2019 that said his stable 2007 has dropped from 12 to 6. His static 99 has gone to -1. That leaves him with a composite score of 5. That makes him a low-range risk offender. And the hearing examiner says, no, I don't have to consider it. It's not part of the same factors or otherwise. Basically, by doing what occurred, they're not compelled to have an expert stand up there and make an opinion that they then have to have an objectively adequate reason to reject. By not having an expert, by saying there's sufficient evidence in a comprehensive evaluation, they're bypassing the need to hear from an expert for me to stand before you 3 years down the road and say, but there's no objective adequate reason to reject it. So I don't think you can, I don't think you can make the leap to say, okay, because he did all those things, and say, okay, now I have a PhD and I can render a diagnosis. The factor says, I'm stuck with this language all the time. It says that there has to be a diagnosis. If there's a diagnosis, the case law says there's got to be an expert.
I want to switch gears a little bit. When the request for an expert was made, it wasn't just with respect to Factor 1. And it said, for example, among other things, there should be an expert with regard to his age.
That's correct.
Are you still, and the response from the board is, no, age is directly addressed by the regulations. You don't, he's not the only 66-year-old person, or 62 at that time. You don't get an expert. Are you still pressing that issue or not?
I didn't argue the case at the hearing level, nor did I get to argue the case at the Superior Court level. What I'm customarily doing in all of my cases now is I'm putting in the studies that say, you know, after age 60, risk drops off the thing. And I've argued this before panels of this court already. I've not gotten any purchase on it yet, but I hope to eventually, which is to say, at some point, the risk falls off the deep end so far that there can't be anything other than a very nominal risk, and I'm not, again, required to show no risk.
But I think Justice Milkey is asking you, and
Am I still making the argument?
Correct me if I'm wrong, but tell us with great specificity what relief you're seeking, what you would have us order.
Remand the matter back so that an expert can be appointed for the purposes of evaluating the individual's existence or non-existence of a mental impairment, his satisfactory completion of sex offender treatment program, and whether or not he has, in fact, experienced the diminution and risk that is associated with attainment of age 60.
Thank you.
That's about as succinct as I can get.
And similar question, you mentioned the PPG issue in the brief more as a matter of fact, then you don't seem to press that issue in your argument. Have you?
I never get anywhere with it because of Daubert.
But Daubert doesn't apply to the board's proceeding.
No, it doesn't, but I believe there's a case out there that says that the board doesn't have to consider it. I seem to remember that. I don't argue it because I usually have that case handed to me. So I seem to recall that it exists. I could be wrong, of course, but I read so many of these cases on a consistent basis that I seem to remember it being there, and as such, I don't believe in wasting your time or mine with throwaway arguments. I always tell my clients, well, we want to argue this, this, and this. I say, that's not what they're there for. They're there to hear what's realistic and not the others.
Well, just by way of preview, a question I'm going to ask Mr. Shanai is, how does the board get to reject PPGs when it wants to and then consider it when it wants to, when it helps the board's position, but that's for
My
him.
brother is one of the most learned individuals I've met. I will relish the opportunity to watch him dance for that. If there are no further questions, I'll rest. You got to enjoy
yes,
this.
on the
Yes,
internet issue.
yes.
This hearing examiner's ruling with respect to that issue is frankly more complete than any I have seen to date. And you say, no, she should have specifically addressed, for example, how probation affected all of that. Why should a hearing examiner have to do that twice? If, in fact, she was correct in assessing your client as a level 3, and given the nature of the sex offenses at issue, why does she separately have to go through the whole probation analysis again?
Well, in preparing for this, I'm glad you asked the question. I read in my brother's brief that it says the hearing examiner gave full credit to Factor 28, probation. I went back and read what the decision says about probation. It doesn't say anything about full credit. It diminishes the credit that is going to be awarded to that. It says it's going to be applied, which gets back to my other argument, which is how can this court properly evaluate without a mental abnormality what weight was afforded to the rest of them. Yet the SJC seems to think nobody has to do that, so that's fine. We all get to guess what was inside this individual's mind when they made the balancing of factors. Fine. That's what I'm stuck with. However, when you get to an issue such as probation and you're assessing dangerousness, how can you not consider access? If you are limited to engaging in sex offender treatment, you're on a strict probationary terms. These are the most strict probation terms I've read in all the time I've been in practice, and it's a long time. And if you basically can't have any contact with anybody, you have to have supervision that has to be approved by probation and otherwise, and yet you don't consider it. When I argue internet access, I fall back on the old case of 137037 that was decided right about the same time as 496501, which says you got to look at the nature of the offense and what they're expected to do. And in any scenario, especially with this guy, with regards to his contact offenses, which gets him to a level 3 in my opinion, he's got to have access. If you want to talk about the voyeuristic activity, fine. 496501 says very clearly that those non-contact offenses, when you consider them on a continuum, probably warrant a level 2. Give me a level 2 and I'll stop talking today and go home. Anything else?
Thank you very much. I applaud your recall on the numbers of these cases.
Do a lot of this.
Mr. Chennai.
If it pleases the court, Your Honor, I'm David Chennai. I think my brother counsel overestimates my legal ability as well as my legal tactician abilities here. I think the point is, if you look at the beginning of 22188, it specifically says the first step is to decide whether or not the evidence clearly dictates the classification in this situation. And the board's position is, yes, that's the situation here. And I think the red flags are in the sex offender treatment records. I mean, this individual, even though he completed treatment,
In fact, that's the whole case, isn't it?
Correct. I mean, but the treatment providers sent up all kinds of red flags even though he completed the treatment, including the fact that they still believed he needed to be in residential treatment because of the sexual drive that he had and his deviancy.
Okay, but the report comes to that conclusion.
Correct.
Saying that, here, this combined static 99R and the stable 2007 comes down to low or moderate. And in spite of that, they say, we think based on this paraphilia and related stuff that he should do residential treatment. That's the essential conclusion of the report, and that is what the hearing examiner appears to hang her hat on.
Correct.
If you knock out the leg of the paraphilia, and because of the lack of the expert, how is it preordained that the hearing examiner would have come out with the same level 3 classification?
I think it goes to the actual contact sex offending behaviors. Because I think when you look at the hearing examiner's decision, she repeatedly refers to that first. That seems to be the main theme that she has. The paraphilias are secondary to the contact sex offenses. The individual who basically grooms young students, female students, one of whom was prepubescent, grooms them and then sexually abuses them. And that he's said in treatment that he's done it over 1,000 times, and that he seemed in treatment to enjoy the whole grooming process. I think that's where the level 3 would have come in, regardless of paraphilias. I think if the hearing examiner said, I'm going to ignore the paraphilias, we're still right where we would be.
You
with the
may
sex
well
offending.
be right, but the issue today is, should we send it back to the hearing examiner to make that decision in the circumstance where she, as I said, appears to have hung her hat on the treatment report, and it's the way it mitigated the low to moderate conclusions by the two actuarial models.
Correct.
That actually goes to my question, which is, we're looking at the test of do the facts, whether or not they clearly dictate the result. Are the actuarial determinations part of those facts that we're looking at?
The hearing examiner considers the actuarial results, but I think under DOE 10800 doesn't have to rely on. In fact, actuarial testing, even when the experts testify, is not conclusive as to risk. It's just one of the elements that you look at. I mean, if you look at any of the experts who testify, they'll say, I gave the static 99R. That is an average. It's not conclusive as to risk.
I'm aware of that, but my question's a little more straightforward. It's, again, in DOE, I'm going to get the number wrong, 22188, we ultimately look at the end of the day to ask, to see if the facts do not clearly dictate a result. Are the actuarial tests, or the actuarial test results, rather, facts?
They are facts for purposes of the classification process. How they're weighed is dependent upon how they factor in with all the other factors. You can get someone who has a high actuarial tables, but that were taken a few years earlier, but then other factors show that there's mitigation that reduces, whatever those results were. And it could be the other way around, where someone's risk could actually be higher than, which is what the hearing examiner found in this case, the actuarial findings on these tests, because the tests themselves, and the hearing examiners are aware that the tests themselves are not conclusive as to risk and danger, would be the answer to that. I think, going back to your question about what to do with this case, I think it would be meaningless to send it back to appoint an expert. I think what you should do, if you're going to send it back, is basically give the individual a new hearing, because in November he was eligible for his reclassification anyways. So you'd be just kind of duplicating the process.
Well, how is that going to be different in reality?
Well, in reality, he has a right to have, say, basically, you could either just, if you found in favor of the board here, he would then turn around and file for a reclassification hearing and start the process again. He could apply for an expert again. And of course, now more time has gone by, that might be helpful to him. He's aged a little more. He may have more stability in the community. Those things may have changed in the last 3 years. I didn't look up to see if he has a criminal record since that point, but those are things that would be factored in if it went back for a reclassification hearing. I would not send it back for an amended decision, because again, he has a right to a hearing at this point anyway, so.
You appear to be sticking to your position in your brief, which is probably a good idea, on the merits of the funding issue. But let's talk about the scope of the expert issue. With respect to age, for example, as I understand the board's theory, it's our regulations now cover age, so age gets factored in. You don't need an expert on that. That argument would have a lot of weight if, in fact, the hearing examiner had applied it in his favor. Instead, the hearing examiner said, I'm going to give it minimal weight because of these other things specific to him. You know, he reports that he has an erection in the morning. We'll leave the colloquial references out. He reports that he once was aroused watching a sex scene in a movie. If the hearing examiner, in spite of the board's regulations, decides that that factor doesn't apply because of things specific to him, why doesn't he get an expert on age as well?
I think Doe 151564, which was Justice Kafker's decision here before he went up to the Supreme Court, he specifically said, if the board's regulations do not consider a factor, in that case specifically age, then the hearing examiner has to look at studies that are submitted regarding age. And what happened was the board updated the regulations and added the age component. Now, the age component specifically says if someone's at a certain age, the hearing examiner has to consider it as to their risk or danger. But there are certain areas, because it's not applied uniformly to all sex offenders, such as sex offenders who have child victims don't get a substantial credit till they're at least 60. More importantly, though, if they still show general criminality or a sex drive, a continued sex drive, the hearing examiner can consider that as reducing the weight. This individual committed his most recent sex offenses at an older age and had exhibited throughout his treatment an increased sex drive. And in fact,
trust me, I'm not saying that they have to make age a major consideration in his favor. The question is more particular, where if the hearing examiner is looking at specific reasons why his age shouldn't help him, then aren't there at least situations where an expert would be needed to assess that? For example, here, the hearing examiner relied on the fact that he committed his, if you will, index offenses when he was 52 and 54, in that range. And now that he's 66, though, how much of a factor is that? Why couldn't a case be made that even in that situation an expert would be needed to address this?
Justice Milkey, I think we're going down the beginning of Factor 2 again in a different version when we started that discussion 12 years ago. The board's position is that the regulation was drafted using all the updated research, and the hearing examiner has the leeway based on what's within the regulation to make those decisions. And in this case, used the fact that the individual, again, was committing sex offenses later in life when he was expected to have a reduced risk, and also that he was still exhibiting a strong sexual drive at the time of the classification hearing based on the MTC records.
Based on what, though? Because my recollection is based on the movie event, waking up with an erection, presumably before he goes to the bathroom, and not a lot else. Oh, there was the fairly damning fact that he sometimes, thought fondly of some of his previous sexual encounters.
You also can't forget that in his treatment records, they specifically said when he would discuss his grooming process, he would get aroused. They could see, that's what they reported in the records, is that when he...
I think excited maybe.
Excited might be.
Then aroused.
I guess I'm putting them both together, but still.
Well, speaking of PPG, could
the
you
PPG.
address my question? Because it's certainly, I have no problem with the hearing examiner saying, reliability has not been established, I'm not going to consider that, even though Ortiz is not binding on me. But if that's true, shouldn't that be a rule of the board and not something that the hearing examiner can say, as they have done in the past, oh, we're going to consider this. Here it hurts the sex offender, and the PPG is damning, so even though its reliability hasn't been determined, I'm going to consider it.
Again, each hearing examiner looks at the evidence differently, and they have a right to look at evidence and decide what applies or doesn't apply. Some hearing examiners...
Why isn't that to some extent a problem? Judges are bound by rules of evidence.
But judges also look at evidence differently. I mean, I've done enough criminal trial work to know that you judge shop for a reason. Certain judges look at facts differently than other judges. It's the same with hearing examiners. It's the same whenever you're going to have people making decisions that are based on evidence presented. Everybody looks at evidence differently. I don't think you're going to get a uniform finding on every piece of evidence that's presented before any panel, any board, or any court, depending on the differences in different judges. So I think that unless the courts say that the PPG cannot be considered, it's really within the discretionary authority of the hearing examiner. Now, I think some hearing examiners do a good job of saying, wait a minute, this happened, this testing was done quite a long time ago, and it really doesn't apply to today's current risk and danger. But again, the PPG really is to look at whether or not there's a sexual attraction. I think they look at it more for a sexual attraction towards children. I think I might have danced around that a little bit.
You still have a minute and a half. That's yours.
You know me, Judge. If there's no other questions, I'm willing to rest on my brief.
Thank you both very much.
Thank you, Your Honor.
The case is submitted, and that concludes our session today. Thanks to the court officers and the clerks and law clerks, and we are adjourned.
Court all rise, please. Court is now in recess.
Always a pleasure.
The problem with arguing for